Hello and welcome to Weber Wenzel's Competition, Trade and Investment Insight Series vidcast, made in collaboration with Africa Legal. I'm your host and moderator, Yael Shafrir. I'm a member of Weber Wenzel's Competition, Trade and Investment team. I'm a trade and investment lawyer with a special interest in FDI, Africa-related investments, investment promotion, and the AFCFTA. In this vidcast, our team of competition, trade, and investment experts will share their knowledge and insights on some of the CTI hottest topics: FDI trends, the AFCFTA, public interest considerations for merger filings, key policy developments in the trade space, and where we stand with investment promotion across the continent. Today, I'm delighted to be joined by members of our competition, trade, and investment team to discuss Africa's ever-changing competition, trade, and investment landscape. I'm firstly joined by one of our partners, Sarah McKenzie, who specializes in international and domestic commercial and treaty arbitration, as well as high-profile regulatory, international trade, and commercial litigation. She has represented parties in many domestic and international arbitrations, including under the auspices of the ICC, ICSID, AFSA, the Chinese Arbitration Association, as well as under UNCTAD. Thank you, Sarah. We also joined by Weber Wenzel partner and competition and consumer protection expert, Burton Phillips. Welcome, Burton. Burton has experience in advising on all competition law aspects of transactions, from due diligence and reviews to engagements with the competition authorities and the Department of Trade, Industry and Competition for SACU. Finally, Matthew Poole, a senior associate in our competition, trade and investment team. Matthew has experience in various trade remedies, including general tariff increase and decrease applications, applications for anti-dumping duties, and general and safeguard applications. Matthew also has experience in general trade advisory work, including World Trade Organization law. Welcome, Matthew. Well, it's a pleasure to have all of you here today to discuss Africa's CTI landscape. Let's dive right in. Sarah, let's start with you. We're seeing increased trends in FDI across Africa. What, in your view, is the investor due diligence that needs to be considered when investing across the region, and what types of protection are available? Over to you, Sarah.
Hi, Anne. Thanks very much. Well, of course, it's very important for any investor investing in a different state to understand the legal and regulatory landscape that they're investing into. At a broad level, you need to understand what laws are going to affect your investment. This, of course, depends on the type of investment you're making. But for example, labor laws, consumer protection laws, competition laws, local content laws, and the like. And then it's very important to figure out what kind of investment protections are going to be available to you in order to ensure that if something does go wrong and your investment isn't treated as one would hope, that you have some kind of remedy available to you. So here we're talking about both substantive protections and procedural protections. In relation to substantive protections, you've got to look at the local legislation in place. In South Africa, for instance, there's a Promotion and Protection of Investment Act that provides some substantive protections. And you'd also want to look at what kind of treaties are available to you. So investment treaties, those can be both bilateral or multilateral, and the types of protections afforded under those treaties. Now, of course, when you're assessing what treaties you might fall within the realm of, you've got to assess the nationality of the investor, and that can depend to a huge extent on the type of investment made and what kind of holding companies it's made through. So there we often look at structuring for clients, and we assess what protections are available depending on which type of nationality we're going to be relying on. The types of treatment protections that you might expect to find in either local legislation or in treaties are things like most favored nation treatment, which says that the investment can't be treated any less favorably than an investment from any other state. National treatment, which says that the investment can't be treated less favorably than then investments from local investors are treated. Fair and equitable treatment, repatriation of profits, physical protection of the investment, and the like. Once you've got all these protections in place and you know what standard of treatment you're going to be, the state you're investing into is going to be held to, you've also got to understand how you're going to be able to enforce those substantive rights. And in order to assess that, we often look for clients at the type of dispute settlement mechanisms available under the local laws or the investment treaties. Those could include state-state arbitration or mediation, mediation between the investor and the host state, being able to rely on procedures in local courts, and hopefully investor-state dispute settlement. Now, that's become quite a controversial term over the last few years, but essentially it's a mechanism in quite a number of investment treaties that allows investors to arbitrate directly against host states. And it's become controversial for a number of reasons, but among them is that states feel that they don't have sufficient space to regulate in the public interest because of this fairly comprehensive procedural right that's available to investors. The other thing we look at is whether the host state is a member of the New York Convention. The New York Convention creates obligations on states to enforce foreign arbitral awards. So if you do have an award against a state flowing from a breach of your investment protection rights, you want to be able to enforce it both in the host state and in any state that the host state may have assets in. So we regularly advise on doing that analysis as well. Quite interesting, Yael, in relation to kind of due diligence processes and what we advise, is that a number of tribunals in investment protection cases have actually recently required that an investor have completed a due diligence of the local laws in order to rely on a fair and equitable treatment standard. And that's because, or the reasoning is that in order to say that your legitimate expectations have not been met or have been breached, you need to have some legitimate expectations. And in order to do so, you need to have really understood what the legal landscape is. So it's important to be able to show that you did do some kind of due diligence when making an investment in order to rely on those types of protections as well. And of course, the nature and content of that due diligence is not something that has necessarily been defined, and so it's quite a nebulous concept, but certainly some form of investigation into local laws that are likely to affect your investment, it really is critical. And then, of course, it's always worth considering the political risk that you're facing when you're making an investment, and it may well be worth looking at the types of political risk insurance that may be available to you.
Thanks so much, Sarah. I mean, that really was a very comprehensive whirlwind tour of the types of issues that investors need to be alive to. I mean, I think just to sort of reinforce what you're saying, we're also seeing increasingly a focus on due diligence across the continent, in both on the risk and the opportunity side. I mean, from an AFCFTA perspective, from an opportunity perspective, I think clients want to do far more of a deep dive into the types of tariffs, incentives, rebates, special economic zones that they may face in their sector in specific jurisdictions. As you said, we're also seeing a lot more focus on risk-type political country risk due diligence. Whereas historically, I think investors may have been scared off by some jurisdictions. I think now they're going in with their eyes wide open. I mean, they're doing proper due diligence. And what we're also seeing a far more holistic, multidisciplinary assessment. So we work with other types of advisors, albeit risk advisors, when we look at political risk. Yeah, and we're seeing the area of due diligence just becoming a lot broader. I think, whereas traditionally used to have quite a set area of due diligence, I think it's becoming a lot broader in terms of, like we said, not just political, but also looking at employee due diligence is becoming very important. Tariffs, anti-bribery and corruption is a key area which clients are looking at, and very much sanctions. I mean, I think clients have become very sensitized to EU and OFAC sanctions, and similarly, they want to make sure that, they're looking at this area when they're investing in Africa. So thanks, Sarah. Moving on, Burton, I think one area which has come up pretty regularly these days is the area of public interest. And I'm very, very interested to hear your thoughts on what type of public interest considerations are we seeing being imposed in merger filings?
Thanks, Jael. Yeah, I mean, certainly there have been a significant number of developments recently from a public interest perspective. And that is on the back of a number of decisions in which both the Commission and the Tribunal have paid a lot more attention to public interest in the context of merger regulations. You may know that our Act mandates the competition authorities to consider competition factors as well as public interest factors when assessing a merger and approving a merger. And ultimately, it may recommend certain conditions to address both competition or public interest factors if such concerns arise, or may even prohibit transactions on the basis of competition or public interest concerns. And a lot of this, or really sort of the turning point from a public interest perspective, if one could see it that way, was the Burger King decision, which was really the first decision where a prohibition was in fact based purely on public interest grounds. And I think that really elevated the public interest factors anew. We do, of course, have the Competition Amendment Act, which makes it clear that public interest factors are now to be considered on par with competition factors. So, I mean, it has resulted in us as competition practitioners becoming public interest lawyers, which I think is a good thing, expanding our knowledge, of course, but also opening up areas for us to get involved in more of the sort of political landscape, and to Sarah's point, understanding some of those elements that are relevant, of course, to merger control. So perhaps that's something to just bear in mind as an opening remark. On the specific public interest elements and conditions that we're seeing, of course, historically, and you can see this trend coming out in many tribunal decisions on merger approvals, employment has been a significant factor for the Commission and still is. Job scarcity, the level of unemployment is, of course, a significant concern in a country like ours. And of course, that will remain a concern for the Commission, and one which the Commission will continue to try and address through merger conditions. So for investors coming in, I think it's very important, perhaps even as early as the due diligence stage, to start looking at what are the potential areas for a transaction to have an impact on employment. That is not necessarily limited to traditional thinking around potential job losses as a result of duplication. It could even be down to whether employees need to be relocated, whether there will be changes, substantive changes in employee contracts or terms of employment. And those are the kind of things that the Commission is delving into. It's looking at the effect on employees relative to whether it's on a sort of management level versus sort of lower level employees, which I think is obviously where the concern arises. And so on the back of that, a lot of the conditions that we've seen from an employment perspective relates to obviously the prevention of job losses, moratoriums on retrenchments for a certain period of time to the extent that such retrenchments can't be avoided. We've also seen conditions that speak to providing training, establishing a support fund for employees that may be affected by transactions, and that I think has come out, and a lot of parties investing in South Africa are actually now looking at making those sort of transactions part, or those sort of public interest conditions part of the transaction upfront, and say, look, we're coming in, this is what we're going to be offering from a public interest perspective, from an employment perspective, of course, to reinforce the importance of public interest. That's not, of course, to say that every single transaction justifies you positioning it in that way. And of course, one would need to consider exactly what public interest impact the transaction may have. So that's employment. The other big one, which I think is a critical one, particularly if one looks at it from the perspective of FDI, is the impact of transactions on shareholdings held by historically disadvantaged persons. And that is at the moment quite a important factor for the Commission. Almost in every transaction that we're seeing notified to the Commission, this is coming up. And there's various views around what the impact should be, whether it is sufficient for a transaction to be purely neutral from a public interest perspective, or whether in fact a transaction should promote a greater spread of ownership by historically disadvantaged persons. In fact, the latter interpretation seems to be one which the authorities may be leaning towards, because that's sort of the wording of the Amendment Act. And one would imagine, coming in, as a foreign investor, there may be an element to which one needs to take into account whether the business that you're investing in has a percentage of shareholding held by historically disadvantaged persons, and whether as a result of such investment that percentage shareholding might reduce, or whether you would want to keep that intact, or whether you may want to consider partnering with a historically disadvantaged shareholder from the outset, as a means to one, obviously, speak to the public interest mandate, but obviously that also has other consequences for the business and your appetite to engage in the transaction, particularly from a structuring perspective. So, I would say those are the two key ones. The others that we're seeing also relates to, a level of protection over local supply, local procurement, investments being made in the supply chain, and that's really to ensure that the local industry remains intact or is improved. And so we've seen the Commission often in big conglomerates or foreign transactions impose conditions that speak to protecting the local supply chain and adequate investments being made in the local supply chain to ensure that there's no significant impact from that perspective. So those are, for me, I think, the key ones from a FDI perspective.
Thanks, Burton. That's really interesting. There is just one question that came to mind, and I just thought I'd throw it out there because obviously we're looking at the Department of Trade, Industry and Competition from a SACU perspective. What are we seeing similar trends across the continent? I know you do a lot of competition work also across the continent. Just throwing it out there, or is this quite region specific from your perspective?
Yeah, that's a very good point, and something important to bear in mind, because we often deal with transactions that might primarily be a South Africa-based transaction, but because of the fact that the parties to the transaction also generate revenue or control assets in other jurisdictions, that it triggers approvals there. Historically, South Africa has been the sort of outlier in its focus on public interest, particularly around employment. But we are seeing this trend more and more in other jurisdictions. So it certainly is no longer unique to South Africa. In a number of transactions, we've encountered authorities looking at public interest. In some jurisdictions, for example, we take transactions in Zambia, you actually have to make certain submissions up front around employment impact around the public interest in Zambia. They may have differing factors as to what they consider to be public interest elements to a transaction. But certainly, the public interest aspects are there. We've seen decisions coming out of Botswana, for example, where conditions that speak specifically to employment as well as local supply have been imposed in transactions. So very good point, and certainly something that is an increased focus for competition authorities on the continent, and certainly not unique to South Africa.
Thanks, Burton. So public interest is here to stay. Moving over to you, Matthew, I think staying with the area of policy, and I'm just quite curious in your work, what are you seeing are the policy areas that the Department of Trade, Industry and Competition is looking into? What are the trends that we're experiencing?
Thanks, Yael. And I think from an industrial policy perspective, it's very similar to what Burton's just covered. So broadly speaking, the two most important policy considerations are going to be employment and investment. So both the International Trade Administration Commission and the DTIC want to know that applicants for protective measures from them, such as tariff increases, are committed to investment in the South African and, more broadly speaking, the Southern African Customs Union economies. So this involves often in an application, for example, for a tariff increase. Upfront, you need to make certain commitments regarding either job creation or job retention. And those commitments often include for specified categories, such as youth unemployment, which is obviously quite an important one in our country. You also have to make commitments on investments in capital expenditure. So either increasing your production capacity, making sure that you can meet demand, and then also investments in skills development and training for your employees, research and development into new products to increase your competitiveness. And similarly, also to what Burton mentioned, you have to commit to support participation in manufacturing by small businesses, Black-owned or Black-managed enterprises, and common customs area supply chains. So not only South Africa, but also our neighboring countries.
Thank you, Matthew. So I think, Sarah, before we move into a more sector-focused discussion, I think it would be good to kind of take a moment and kind of, if you could share with us where we stand with regards to the current status of the investment protocol under the AfCFTA.
Sure, Yael. So the African Continental Free Trade Agreement Investment Protocol is still being negotiated. We do see it, however, as a critical component of Africa's success. Of course, with increased trade and investment comes an increased need to ensure that investments are fairly treated. And as I mentioned earlier, there are a whole bunch of components to that. The investment protocol, of course, would essentially form a fairly comprehensive multilateral investment treaty that affords investors throughout the continent substantive and procedural protections. There has been a fairly inconsistent approach to investment protection on the continent until now, with various overlapping treaties which provide different standards and different approaches being taken by different states on the continent. Some of the key negotiation points that we think are probably critical in what's going on at state level is the investor-state dispute settlement question. As I mentioned earlier, that's become a fairly controversial topic globally, with questions around its legitimacy. We also think that some of the substantive protections are likely to be hot topics in the negotiations, including the fair and equitable treatment standard, which is relatively nebulous and often relied on by investors, but hard to pin down a precise definition of. And the question around whether there should be various requirements on investors in order to get treaty protection. So have the investors complied with local laws? Are they contributing to the economy? Are they protecting and promoting human rights and the like? Some states have opted recently to do away with investor-state dispute settlements in relation to their investment protection regimes going forward, South Africa among them. And there's a key concern among many African states about whether they have sufficient ability to regulate in the public interest. There's hope for harmonization, I think, flowing from the investment protection protocol, and we are hoping to see a strong but consistent approach that can be applied across the continent coming out of these negotiations. There have been various developments which give us some clues in relation to what the protocol may ultimately look like. The first is the Pan-African Investment Code, which is a non-binding instrument that the African states have adopted. In relation to investor-state dispute settlement, the hot topic I've referred to a number of times, the compromise reached among African states in the code was that there wouldn't be compulsory investor-state dispute settlement, and this has been left to the discretion of African states. Similarly, in the SADC Finance and Investment Protocol, no investor-state dispute settlement, flowing from, I think, a fair amount of pressure from South Africa in relation to the policy decisions that have been taken here. But we have, in fact, seen what's referred to as the zero draft of the investment protocol. And although it's certainly no final version, it does give us some clues about what the final draft may ultimately look like. Interestingly, the zero draft contemplates the termination of all intra-African bilateral investment treaties, which of course would go some way towards the harmonization that we're hoping to see. It leaves out the fair and equitable treatment standard, instead opting for a question of due process in relation to administrative and judicial treatment. It makes it very clear that state parties will have the right to regulate in the public interest in order to achieve sustainable development goals and other socioeconomic policy objectives, which I think is a very welcome addition, and I think will give a lot of state parties a huge amount of comfort. It does include those investor requirements in relation to human rights, compliance with the law, and the like, and also includes an option for counterclaims and investor liability, which I think is also something that host states have been quite interested in achieving. There is, interestingly, investor-state dispute settlement in the zero draft, so we'll see where that lands up. I think that is likely to be a topic that will continue to be negotiated going forward. But of course, consensus is necessary. So I think what will ultimately come out of the negotiations is some kind of middle ground. And of course, a critical middle ground for the success of this free trade agreement.
Thanks, Sarah. That I think that'll give investors, the zero draft should give investors, some comfort, and I think my view personally is that this increased governance is going to be a key driver in terms of driving FDI into the continent. So, and also seeing the introduction of the SDGs, I think all of this will go a long way to giving increased comfort to investors. So I think I'd like to move on to transition to a sector-focused discussion. And maybe starting off with some of the key sectors that we've seen the AFCFTA Secretariat focus on and prioritize. And these very much align with where we're seeing a lot of the activity. So one of them is automotive, but not just automotive, also mobility in general. I mean, we've seen a lot of activity in the 2- and 3-wheeler space, generally public transport, e-hailing, and the prospect of EV. So this is going to be an interesting space to watch. Agribusiness and agri-processing. I know that we're seeing a lot of activity in that space. Healthcare and pharmaceuticals, and clearly COVID was a key driver in terms of, the continent wanting to become self-sufficient in this area. And then finally, transport and logistics. So I think, Matthew, I'd like to turn to you and ask you from your perspective and in your practice, which sectors do you see getting particular attention?
Thanks, yeah. So obviously one major sector over the past few years in the Southern African Customs Union has been the steel sector. So we've seen for several years now a number of applications being brought by domestic industries for increased protection. So that's a form of that increases in ordinary customs duty. There have been several safeguard measures and also applications for anti-dumping measures. But what we're also seeing in that sector is applications from downstream manufacturers for rebate provisions to ensure that they have access to products that might not necessarily be produced within the customs union. So they get access to those products duty-free, whilst also affording protection to the upstream producers. Another major sector that we see activity in is agriculture, which is especially important there because we need a strong domestic industry in order to maintain regional food security, which is obviously quite important for us. And then we're seeing increasingly from chemicals and paper manufacturing industries, as well as construction equipment and supplies and small appliances. So a lot of different sectors across the economy where there is scope for job creation and job retention.
Thank you, Matthew. Burton, anything to add from what you're seeing in your competition practice?
Yeah. I think very much in line with what Matthew said. I think one of the key indicators for us is if you look at the market inquiries that's been undertaken by the Commission in recent times. There've been market inquiries in the healthcare space, in the LPG gas space. There was the big market inquiry into data and the price of data in South Africa. And there's currently the market inquiry that is looking into online intermediation services. So, I mean, that really sort of gives you a sense of where the Commission's focus is lying. I mean, there is an increased sense that the digital economy is one which the Commission will be focusing on. In 2020, the Commission published a paper on competition in the digital market in South Africa, which really seemed to be positioned as a blueprint for the Commission in terms of how it will tackle competition in the digital market. I think there is a sense of recognition that there may have been a level of a sort of under enforcement in that sector to date, and that is, I think, a function of how rapidly that market changes. I mean, technology changes almost every day. And of course, for authorities to appropriately regulate that sector, it needs the tools, it needs the know-how, it needs the capacity to be able to do so adequately. And we've seen a number of key strategies set out by the Commission in terms of how it'll do that. One of which, as I've mentioned, is market inquiries. The Commission's also recently published guidelines on small merger notifications, which might lead to an increase of notifications to the Commission of mergers which otherwise would have escaped the scrutiny of the Commission simply based on its size, because the financial thresholds may have not been met. But often what happens is it might be a small merger which doesn't require mandatory approval, but part of that small merger, what's being acquired, is actually key technology or security interests, which is of interest to the Commission and should be reviewed to ensure that, on a long-term basis, there are no significant impacts on the competition or public interest factors. So yeah, I mean, I think digital markets is going to be a key one for the Commission, not only for the authorities in South Africa. We have seen a number of moves by other competition authorities on the continent to collaborate with the Commission in South Africa and other jurisdictions where, of course, these issues have already come up. I mean, one needs only to look at the US and the EU to look at the number of cases in which, big technological companies, your Facebooks, Google, have been investigated for practices around, technology, etc. So there's a level of, I think, education that needs to happen, a level of upskilling that needs to happen on the part of the authorities, but also, these issues are in a lot of instances novel and change as the technology changes. So I think, that'll be an increased focus for some time to come from a digital markets perspective.
Thank you, Burton. I think, and thanks for highlighting that. I think in Africa, where we're seeing so much leapfrogging, the digital space, is going to be one to watch, and definitely regulation in that space is an important one to watch, also under the AfCFTA. Finally, Matthew, I'd like to turn to you and maybe just talk to us from a practical perspective. What are the fair and unfair trade tools which are available to market participants? I think it'd be good to elaborate further in that area. Thanks, Matthew.
Thanks, yeah. Sure. So when we're talking about remedies that are available from a trade perspective, we like to break it down into sort of two groups. So we've got our tariff investigations and then our trade remedies. So both of these, the investigations portion that's conducted by the International Trade Administration Commission, and the ultimate decision is made by the Minister of Trade, Industry and Competition, following a recommendation from ITAC. So when we're talking tariff investigations, we're looking here at changes that affect generally ordinary customs duties. So that's a tax paid on goods entering the common customs area, that's a SACU. And these duties are used as trade and industrial policy instruments by the DTIC. And generally, they're used to promote domestic production, job retention and creation, and also international competitiveness. So if you are a domestic industry and you find yourself facing increased competition from imports, you can approach ITAC for an increase in this ordinary customs duty, provided, as mentioned earlier, you're willing to make commitments on investment and on employment. On the other side of this, where there is no domestic industry or where the domestic industry doesn't produce a particular product, interested parties, so downstream users or importers, can approach ITAC and apply to either to have the duty reduced or removed if there is no domestic industry at all, or for a rebate provision to be created where there is a particular product that is not available within the common customs area. We've got, as DTIC, they've got quite a wide policy range they can consider here. And really the only international restrictions is our commitments to the WTO, not to raise those duties above a certain rate. The trade remedies side, we generally see two types of trade remedies. So you've got anti-dumping duties and you've got safeguard measures. So broadly speaking, anti-dumping duties are available where you've got a foreign producer that is selling a particular product at a lower price in the SACU market, then it sells it in its domestic market. So that's that practice of selling in your export market at a lower price, that's what we call dumping. And the second and third requirement is that dumping must also cause or threaten to cause material injury to a domestic industry. So the domestic industry would bring an application to ITAC. ITAC would carry out its investigation. If they find that there is injurious dumping, duties can then be put in place to offset that dumping. These duties are company and country specific, and they're often in place for a period of 5 years, unless there's a review of those duties before the end, which concludes that the removal would lead to a continuation or recurrence of dumping, in which case the duties can be extended for a further 5 years. That's what we call, that's an unfair trade remedy, but there's also a fair trade remedy, which is a safeguard measure.
Great. Thanks so much, Matthew. And I think thanks so much for highlighting, as we're looking at the importance of the industrialization of the continent, so hand in hand goes the importance of enhancing and protecting industry from unfair trade. So I think it's really important to kind of, make people aware of the types of tools that are available. So I wanted to close this off now and thank you, Sarah, Burton, and Matthew, so much for this very practical and informative discussion of the key hot topics in the competition, trade, and investment space. Thank you so much also to Africa Legal for partnering with us, and have a great day. Goodbye, everyone.